public purpose, and the 5th District said they needed to be compensated for the time that they actually flooded the property. White versus Pinellas County, I'd say this is the closest case we have in Florida to the issue that we're talking about, which is the temporary physical occupation of private property by a government agent or entity. Here, there were some agents of I guess Pinellas County, I guess you can say that. Some agents from Pinellas County came in and they cut down trees and cleared and brushed private property during a road project, and that was some of this has to do with a pleading issue that it was pled that they came and did it as part of a road improvement project. Pinellas County denied that was actually part of the road improvement project, and so that's where you get some of this opinion kind of. Most of the opinion, I think, revolved around that pleading issue. The Supreme Court disagreed and said that if it was done for a public purpose, that is, that the trees and the clearing and brushing occurred for a public purpose, then there was a taking for the time when they came in and cleared the property and cut down the trees. And it's important in Pinellas County that the county made the same argument. They said, look, all we did was come in and cut down some trees. If anything, we trespassed on this property, but we're not liable for anything, for a cause of action adverse condemnation. The Supreme Court disagreed, but again, because you have the pleading issue, all they said was, if it was done for a public purpose, then a taking occurred. There was never any determination of whether it had occurred for a public purpose, and so that's why it isn't as strong as you might like. In that, they relied in part on the Darby case, which again says, if you need it, you got to take it. Edwards Dairy. I think this is a good case. It's instructive. It's a permanent case, but the thing that I like most about this case is they talk about entry and appropriation. And when you talk about the guy eating lunch on the property and the use of the property for storage of vehicles and material, I think that's the difference between eating lunch on a piece of property and taking it for a TCE. Would be both the entry and the appropriation. If you've got entry only, I really don't think you've got a taking. But if you can articulate an appropriation of the property, then I think you're getting towards a taking. The conclusions that that we draw from this research, there's no precise test. We don't have a great case in Florida. The best cases, Hendler, which is a Court of Appeals case, federal court. We've got White versus Pinellas County, but again, you've got issues in that make it less than ideal for helping us determine a precise test. But what I would say is, based on my research, I feel like you obviously got to have the entry, but entry just gets you to either trespass or a taking. And I think that the appropriation, an articulated appropriation in public purpose is what really takes it from a trespass to a taking. And if you don't have a public purpose, for the reason that whatever has happened and whatever is going on in the property, I really don't think that you've got to take it. So I've tried to make that quick. Hopefully I didn't stand up here too long in the way of the reception. I don't know if anyone has any questions.